we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, the petitioner is allowed 4 months' time from today to vacate and hand over the possession of the subject premises to the respondent landlord. Petitioner shall submit undertaking before the registry to the effect that he shall hand over vacant possession on or before 30th May 2026. Yes.
May I please Lordship, here respondent number 1 is convicted under section 302 and he has been suspended, his sentence and bail is granted when he just undergone 3.5 years. Lordship, what waited to the mind of the Honorable High Court is that this is a case of single blow, but actually that is completely incorrect. There were multiple blows were given on the head of the deceased by a stone as well as paver block and trident.
Where is postmortem report?
Just see, evidence of doctor is there. Postmortem I annexed in additional document, but if Lordship will see page 88 is the doctor's evidence. He mentions the injuries. Page 88 injuries, Lordship can see. Surgical stitch mark 10 centimeter into 0.5 cm. Shaped present on right frontal parental temporal scalp. Second injury 20 cm into 0.5 cm involving left frontal partial temporal scalp. There are internal 6 injuries are internal also. And 89, kindly see the cause of death given by the doctor. Death is due to head injury and its complications. If Lordship will see page 114, how the Sessions Court has dealt with this, that will make a clear.
Only 2 injuries.
No, Lordship, if Lordship will see, there was a CT scan and this was a surgery was performed on his head. Therefore, it is seen prima facie 2 injuries. But there is a CT scan report which gave a 7-8 injuries, which I annexed. If Lordship will see the trial court's judgment at page 114.
No, you have seen, you are showing us page 88.
Page 88.
Page 88, paragraph 2 called last 2 injuries.
Yes.
Only 2 injuries are mentioned.
Two injuries and there are some internal injuries.
Multiple injuries.
There are internal injuries, but if Lordship will see 114.
Either High Court has decided it finally, nor we are deciding it finally.
Yes.
Whether it is 2 or 3 or multiple or internal or is only suspension of sentence.
But only 3.5 years. There is a case of I-PAC. Lordship will see 114, page number 114. Kindly see. Para 28.
114?
Yes, Lordship. Para 28.
Yes.
After going through the evidence of record, I find that Basuki Nath Jha assaulted Jitendra Nath Jha on 1921 by stone, paver block and trishul over the head of Basuri Nath Jha. I further find that P.W. Ken, who is doctor who examined Jitendra Nath Jha on 1921 and examined a CT scan report of Jitendra Nath Jha, found several injuries on the head of Jitendra Nath Jha. One, extradural hematoma in left temporal lobe, thin subdural hematoma. Third injury is a small hemographic contusion, and fourth is a linear fracture in left temporal partial bone. Although in his cross-examination, doctor has admitted that he has not compared injury found on the body of injured with CT scan report, who themselves not fatal to the prosecution case, because all the 4 injuries mentioned in CT scan appears to be internal injury and only to be detected by doing the CT scan. I also find that PW11 after alleged occurrence of 1921, Jitendra Nath Jha was admitted to the hospital. And if thereafter Lordship will see page 116, till the conclusions are recorded by the learned session judge. He said, keeping in view the several head injuries caused over the head of Jitendranath Jha as a result of
We will not deal with your argument in detail because otherwise it may
appeal
case.
So one submission our pages
On hearing learned counsel for the parties, we are not inclined to entertain the SLP. Accordingly, the SLP is dismissed.
Sir, one submission our pages be marked. They are not taking online our pages. Our pages.
Physical privilege.
Okay.
But in this case, it pertains to an intermediate recovery of an NDPS millet's contraband. But the brief facts of the case are on 16/4/2024, as the petitioner was apprehended.
First case.
Please, my lord. The arrest is vitiated since no, my lord.
For alleged recovery of 12 kg 250 grams ganja within bucket intermediate quantities. The petitioner is in jail since 16/4/2024. Submitted by counsel for the petitioner that for alleged recovery. It is also submitted that petitioner has no criminal antecedent. Issue notice.
I'm no straight.
Item 25.
I appear on advance notice in item 25.
Item 25, this is a case of an anticipatory bail. My name has been disclosed by the main accused in the disclosure statement. The total quantity which is recovered from the main accused is 1 kilo and 800 grams of poppy husk, which is not a commercial quantity, number one. But then,
Yes.
please. The main accused has already been granted bail, my lord. We have annexed the order as speaking, my lord. As far as the antecedents are concerned, my lord, Government Counsel says before the learned special judge that I have 15 FIRs against me, which is an incorrect statement.
2+7.
2+7, my lord.
Yes.
2 FIRs, my lord, under NDPS and 7 under
Even
excise.
one is sufficient.
Very well, my lord.
For anticipatory bail, even one is sufficient.
I'm on the disclosure statement of the main accused. She has already been granted bail.
Main accused is the wife. Because main accused is the wife.
Antecedent.
But antecedents.
Not only on quantity.
I'm on the bail in 2 NDPS, my lord, and 7 excise act, my lord. I'm on the
It's only
acquittal.
because of that you are committing this crime.
My lord, acquittal, my
You
lord.
have been granted bail in earlier 2 cases. You are continuing. And this is Punjab.
So that's a presumption, my lord, that what is learned special judge as well as the High Court order. That
No, what presumption?
specifically says, my lord.
Section
What
29.
government counsel says, my lord.
Section 29 presumptions.
No, my lord, I'm not
Section
saying.
29 presumption applies to an accused, not to a state.
Certainly, my lord. But already on regular bail in those NDPS.
Sorry.
Main accused is the wife, my lord.
Dismissed.
So she has already been granted bail, main accused, my lord.
Point bencher.
Yes, my lord. My friend is not saying that the main accused is the wife of the petitioner, and he's saying he's insisting on being that co-accused.
She has already been
From the
granted
same
bail.
family, everybody is there. They have a nexus going on.
That shows they are moving well in life. Yes.
My lord's appearance may be taken.
Yes. Yeah.
Yes,
Yes.
26.
appear for state honors. This is the matter implicated only on the basis of suspicion.
Duplicate?
Implicated only on the basis of suspicion. First thing. Second thing is that the alleged incident was happened on 5/8.
Antecedent also.
Antecedent, there are
Yes.
antecedents. Made a chart also. But the other part is that the investigation officer taken me into custody on 5 days. Now produced me on 9. That is another aspect apart from the merit. In the remand report also, in the CCTV footage Pancharama also, that is very specific.
Early morning. There is no eyewitness, but this is a case of
What is the
circumstantial
recovery
evidence.
against him?
But recovery,
recovery against-
but remand report mentions there is a blood-stained axe recovered from at his BS, my lord, at page 40, my lord.
You file counter and point out the evidence.
I'll file it, my lord.
Notice. Returnable on 10th February. 10th February.
Grateful.
Mr. Counsel,
Yes, my lord.
इनका नाम लिख लेना.
Samrat Shinde. I'll give my appearance, my lord.
Physical appearance.
Yes, my lord, I'll give.
Mr. Samrat Singh, the Council of Hearing for Respondent State of Maharashtra, undertakes to file counter affidavit, waives notice and undertakes to file counter affidavit before the next date of hearing.
Samrat Shinde.
Item 27.
But item 27 reflects, my lord, a very shocking state of pattern emerging. This is one incident. Lord, I have narrated in past also, whenever statutory authorities exercising statutory powers of investigation goes there, Lord, the Honorable Chief Minister barges into the premises of the, wherever, my lord, this is conducted.
How is this maintainable?
I'll, my lord, come to that. Lord, the officers, my lord, Director General of Police, the Commissioner of Police, they accompany her, they are accomplices, they, my lord, abate the offence, and thereafter, my lord, I'll place on record, I have prepared it, my lord, they sit on dharna, the uniformed service officers sit on dharna with political leaders, my lord. Now, my lord, on maintainability. Lord, maintainability, there are two petitions, my lord, one by the Enforcement Directorate and another Enforcement Directorate along with one officer, Lord, who is personally agreed. He is a citizen of India. And, my lord, there is a second petition by two individual officers.
28.
Yes, my lord. And I have, my lord, narrated earlier incident also where Joint Director CBI's house was ransacked, my lord. It was gherowed by people, my lord, stones were pelted. He was giving, my lord, frantic calls to survive him, to my lord,
Yes.
Here, my lord, there was an evidence leading to, my lord, a conclusion that there is some incriminating material lying in one premises of a company and premises of one individual. My lord, the officers exercising powers under section 17 of PMLA goes there. They intimate the local police that we are going there. The Honorable Chief Minister, who is joined as a party, along with the Director General of Police, along with the Commissioner of Police, along with the DCP of the area, and large police force goes there, barges into the house. Whatever material was collected was taken over unauthorizedly, which according to me, my lord, I have not hidden anything, and I am not feeling shy of saying it's an offence of theft. It's an offence of, there are several offences, my lord, which I have mentioned. She takes it away, including, my lord, one of the mobile phones of ED officials. And, my lord, thereafter, there is no question of, my lord, my proving it. The respondent number 2 goes before the media and says that this is the great thing I have done. Lord, if this is, my lord, turning a blind eye to, Lord, this kind of things will continue, which will encourage not only the people in public life, it will encourage the officials, my lord, to not discharge their duty. They would, the central forces will be demoralized and the state forces will feel that yes, we can go with the Chief Minister, we barge into somebody's premises, we collect the evidence, we commit theft of the evidence, and thereafter, if needed, we will sit on dharna also along with the Chief Minister. So, my lord, I am moving an application seeking a specific prayer that let that example be set that the officers who were admittedly present, my lord, during our exercise of powers under section 17 be placed under suspension, and my lord, let there be, my lord, a departmental inquiry, because this is a serious misconduct, even department.
You want us to suspend?
My lord, your lordships may direct the competent authority to suspend. That's the prayer. Now, my lord, we approach the High Court. Please see, my lord, what happened in the High Court, my lord, page 1.
There is no such we have not read.
No, my lord, it is filed e-file. Lord, I have the copy, my lord. They are served.
Served at 8 o'clock in the morning.
Yes, yes, it is served, my lord. It is served late.
I'm not disputing that. I'm just.
I'm not saying. It is served late,
Yes, yes.
but it is, my lord, filed. Please see, my lord, my prayer. But this is something very, very serious, your lord.
Yeah.
May please take, my lord, cognizance of what is happening. Lord, first, see, I have quoted section 54 in my lord, context of the officers. Section 54 at page 5. The lordships gets, my lord, page 5.
Yes.
My lord, this is PMLA Act, section 54. Certain officers and others to assist in inquiry, etc. The following officers are hereby empowered and required to assist the authorities in the enforcement of this act. One of them is officers of the police. And here police comes along with the chief minister to ensure that the evidence collected is removed by them under their supervision, under that threat. But please have a look at, my lord, the prayer. Prayer, my lord, on the same page. Pass an order or direction placing under suspension respondent number 3, 4 and 5 and any other police officer present during the raid conducted by the Enforcement Directorate on 8th of January 26. Direct the newly implemented respondent number 7 to 9. That is, my lord, the Chief Secretary and, my lord, their cadre controlling authorities, my lord, which I am seeking to implement, to initiate departmental inquiry proceedings for major penalty. But, my lord, right now, my lord, we are concerned, my lord, the pattern is this. Lord, I have given the examples and I'll take your lordships to those examples, shocking examples. Lord, earlier the CBI officers go. Lord, they do not go on their own. There is a judicial order passed by this honorable court directing investigation into some cheat fund offences. Lord, there is discharge of their duty. The police officers are, the CBI officers are arrested and taken to the police station. The chief minister comes at the residence of the then police commissioner, who happens to be the director general of police today, and stages a dharna on the gates so that nobody can enter. The CBI officials, armed with, Lord, the order of this court under an obligation to investigate in a different offence, Lord, are not permitted to do that. There are, Lord, there was a bail application, my lord, and I am placing, my lord, those pleadings on record. There was a bail application of the law minister of the state being, one of the accused, a very prominent leader. The sitting law minister goes inside the courtroom and sits there with a crowd of 5,000 people shouting slogans. So there are several things, my lord, we want to see. Even in this case, my lord, this is the position. And my lord, another thing, my lord, kindly, my lord, appreciate.
Yes, 1 minute.
Yes, but kindly see what happened in this particular case. Please come to page 121. Lord, we approach the Honorable High Court. Page 121 may be seen. This is what happens when mobocracy replaces democracy. 121. This is what the Honorable Judge of the High Court, Lord, records in a judicial order passed. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. Request made by the court to maintain the decorum and dignity of the court so as that the matter can be taken up for consideration fell on deaf ears. The environment in the court is not conducive to commence or continue with the hearing. In view of such situation, my lord, the court says it's not conducive for hearing. In view of such situation, this court is constrained to adjourn the matter. Let the matter appear under the heading new motion on so and so.
Yesterday.
No, my lord, this was earlier. Now, my lord, your lordships, my lord, our innocent guess would.
Ninth, my lord, ninth.
It's
Yesterday the hearing took place, there was no ruckus.
Yes, yes.
Yesterday the hearing.
I forgot what happened. I was there.
I was there, I saw what happened.
You should not have been there.
Deliberately.
Why should I be there?
I was
Why should I be
preventing
there?
speaking. My mic
I
is
saw
not.
it,
Only a
it is
minute,
on
only a
video.
No.
It is on video. I saw the video later in the day.
My learned friend.
Itself.
Yes, exactly.
Yes, my lord, my learned friend vehemence,
Let him.
Lord, I understand.
Your-
But yeah,
Don't
our,
put any ruckus here, please continue.
no, my lord,
Continue, please.
our, my lord, innocent thinking can be, after reading the judicial order of the learned judge, that maybe because of the sensitivity of the matter, the lawyers may have gone, some people, other people also may have gone out of curiosity, and that might have resulted into an unintentional kind of a chaos and chaotic situation. I have placed on record the WhatsApp chats that the Lord, the law wing of the party in power, my lord, of which the chief
No, it's
minister.
intentional or unintentional, but the High Court has recorded something.
Yes, my lord, and this was not, my lord, this was not spontaneous. My lord, they were all instructed by the legal cell of the parties to go there. That is page 119, my lord. This is, my lord, the WhatsApp message, my lord, one of the WhatsApp message from the legal cell of the party, my lord. Today on 9th January, court number 5, item 10. Come everyone. Lord, he is convener, Mr. Amit Kumar Das, convener, High Court. Then, my lord, second, gathering today at 1 p.m. at B gate.
Come everyone, as if it is Jantar Mantar.
Yes, the court is converted into Jantar Mantar. Lord, kindly read the second part. Today 9-1 is the first. But today 9-1-26, court number 5, item number 10. Come everyone. Lord, this matter, which the learned judge records on 9-1, which your lordships have read at page 121. Next, gathering today at 1 p.m. at B gate. Come everyone. Will go to the procession of the Honorable CM so and so. Bus and vehicles are arranged. This is the, my lord, preparation. Yesterday, Lord, the Trinamool Congress, the party in power, filed a petition. In that, before the petition comes for hearing, look at the position in the High Court. The Honorable Acting Chief Justice then had to pass an order that nobody will be permitted to enter in this courtroom except the lawyers appearing, and it will be live telecast. It was only because of that, my lord, precaution that some hearing took place. That also, my lord, was less than, my lord, satisfactory. My learned my lord, senior friend appeared, and my lord, we faced several difficulties. I don't wish to say that, my lord. Here, if needed, we'll file even an affidavit. His mic was being constantly muted. So these are, my lord, the issues. Your lordship,
But it is in the control of the court.
Lord, I don't wish to go into it, my lord. This is a petition for seeking protection of my fundamental rights. We are officers. Lord, the ED is not an organization only. Lord, under section 7 and 8, whatever, my lord, we recover, we don't recover for our personal purposes.
This, what is he handed over?
But it is this instructions issued by the court.
Yes, my lord. This is something very rare. Even the Honorable Chief Justice is aware that it otherwise cannot be, matter cannot be heard. This is the position, my lord. Now, please see, my lord, the act. What is ED, my lord, on the maintainability? Let me satisfy your lordships. Lord, please come to page, section 8 of the PMLA. Lord, what is the role of ED in the scheme of the PMLA Act? So it's not just an organ, merely an organ of the union government. But we exist for this purpose. That's what, my Lord, I'm trying to show.
Subsection 8 of it.
My Lord, section 8, your lordships have?
Yes.
My Lord, adjudication. Please come to subsection 8 now. Now, my Lord, we do everything. We, my Lord, attach the property. We take the property in our possession. Thereafter, confiscation proceedings, etc. Ultimately, what? Who is the ultimate beneficiary? Please see section 8. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence of money laundering.
Subsection?
8, subsection 8 of section 8.
Yes.
I read again, my Lord, for your lordship's convenience. Lord, we go far through.
Where a property stands.
My Lord, first is attachment, thereafter, my Lord, taking possession. All, my Lord, there are some provisions for appeal, etc. But eventually, when it is confiscated, my Lord, this is what happens. The victim gets the benefit of this laundered money. My Lord, that's what I want to show. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence of money laundering. Now, my lords, what we do, my lord, just to give an example, so that I am showing my, my lord, locus to approach your lordships. Because I represent, my lord, those victims. My lord, suppose I am investigating money laundering in a bank. The bank goes in, my lord, liquidation or something happens, my lord, to the depositors. My lord, this amount which we collect will go to those depositors. My lord, the ED has so far, my lord, collected more than 30,000 crores and which are given to the victims of the crime. So we are not just an organization. My lord, we represent the will or, my lord, the interest, if not the will, of those victims of the offence to safeguard their interest. But, my lord, petitioner number 1 is the Enforcement Directorate. Petitioner number 2 is an individual officer. My lord, we are now, what they do is, there are 3 FIRs filed against us by 2 by the Hon'ble Chief Minister, 1 by the police against us, that we did something illegal, we browbeated them, etc., etc. Based on, and this is something very shocking, based on that FIR, they came to the scene of the offence which they committed and removed the CCTV footage.
So what for you went there? And what?
Under section 17 for seizure, for kindly see, search and seizure.
What was under the investigation?
Yes, my lord, please come to page B. Please come to, my lord, page B, second para.
Page?
B for Bombay.
B for Bombay, my lord, my synopsis. My lord, they say that we went for collecting SIR data, my lord. A fool will not go to collect SIR data which is available on the website. B. The petitioners are constrained to approach this honorable court under the most extraordinary, unusual and unfortunate circumstances emerging from the petitioner. As pointed out in detail hereunder, the petitioner is investigating a multi-state money laundering offence under which the proceeds of crime to the tune of rupees 2742 of 0.32 crores are derived from the illegal coal mining.
This offence, this particular scam is being investigated.
Yes, by us, my lord.
And for this you went inside.
Yes, my lord. Now please oblige me by coming to page 5. Page 5. This offence is being investigated. Page 5, para 5. Para 5. Page 5, para 5 at the foot. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold in Shakambari group of companies On analysis of the documents seized from the premises of so-and-so, so-and-so and so-and-so, it is revealed that so-and-so group used to receive cash from so-and-so group against sale of illegal excavated coal. So-and-so group of companies are primarily into steel manufacturing. The group is led by so-and-so, who is the managing director of so-and-so limited and is also director in other group companies. From the evidence collected by the petitioner, it is evident that coal used to be purchased by so-and-so group of companies owned and controlled by so-and-so from coal syndicate led by so-and-so. The payment for the coal used to be made in cash. The so-and-so has not complied with the summons issued for recording his statement under section 50 PMLA. The act of purchasing illegally excavated coal from so-and-so constitutes offence of money laundering in the hands of so-and-so and so-and-so. It was therefore proposed that residents of so-and-so and corporate office of Shakambari Group be searched under section 17 as they have committed an act which constitute money laundering and are in possession of records relating to the offence of money laundering. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international hawala. One such hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so. Hawala firm named so-and-so was used for hawala transfers by the coal syndicate as seen from the WhatsApp chats. Intelligence was received that around 20 crores of proceeds of crime from Kolkata to Goa was transferred through so-and-so firm. The employee who handled the hawala transfer at so-and-so is so-and-so. Material evidence has been gathered which disclosed that 20 crores of proceeds of crime arising from illegal coal mining were used through interstate hawala networks layered through a chain of felicitations, converted into cash at Goa and channeled into, now please see, IPAC. This is
not felicitation, it is facilitation.
Facilitation, I'm sorry. It means, the meaning changes drastically. I stand corrected. My apologies. IPAC's operational framework. This is IPAC where we went. And for search under section 17 of the Act. Operational framework by being handed over to persons executing its work. Thus, the search proceedings were started at 10 different premises situated in Delhi and Kolkata on 8th January 26. Out of the said 10 premises, one of the premises was the
same I-PAC with which earlier Mr. Sam Kishore was associated.
Yes. 10 premises, one of the premises was the residence of Mr. Pratik Jain, situated at so-and-so, Calcutta. Sri so-and-so assistant director was authorized by Sri Bansal, deputy director, with the authorization number so-and-so to carry out the search and seizure proceedings at the said residential premises of Mr. Pratik Jain under section 17 PMLA. During the course of such proceedings at the office premises of Messrs. Indian PAC Consulting Private Limited and the residence premises of Mr. Jain, certain police personnel has arrived at their respective premises and asked the officers conducting the search to intimate a local police station if they wanted to continue their search. During the course of the search at the residential premises of Mr. Pratik Jain,
this authorization the officers were possessed of.
Yes, my lord, we showed they grounded. As a matter of fact, we intimated them in advance by mail. Even on that day it was shown.
Person in charge of the premises.
Premises also, that this is the authority under which we are coming, and we are not interested in any of your political activities, if any. We are confining only to this, my lord. But I do not know what was there to hide that such a drastic step has to be taken that the Chief Minister herself personally barges into it, along with the Director General of Police and Commissioner of Police and DCP and the entire police force. Then, my lord, further, during the course of the search at a residential premises of Mr. Pratik Jain, situated at so-and-so on 8/1/2026, various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of such search at around 11:15 a.m., Sri so-and-so, Deputy Commissioner of Police South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and the search authorization letter. Thereafter, Shri Manoj Kumar Verma, IPS, the Commissioner of Police, Kolkata, also entered the premises as the police officers were being briefed about the search proceedings under section 17 PMLA at around 12:05 PM. Miss So-and-so, sitting Honorable Chief Minister of the West Bengal, duly identified, entered the premises despite making categorical requests for not interfering with ongoing search proceedings under PMLA. However, violating all law and order, Miss So-and-so, with the aids of police, forcibly took possession of all digital devices and incriminating document from the possession of authorized officer, Shri So-and-so, Assistant Director, and left, he is the petitioner before your lordship, and left the premises at around 12:15 PM. All the proceedings have been recorded in Panchanama, duly drawn at the premises on 8/1/26. An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. Lord, please see the totality of this. Section 17 authorizes the search. The person searching has the authority later. The people who come, my Lord, the DG, police commissioner, everyone is shown those things. That these are our identity cards, this is our authority later under the statute. And they have, my Lord, this, Lord, I'll not use any adjective, my Lord, but courage to take the incriminating material in their custody, which is a theft. Go and, my Lord, thereafter publicly declare that this is what we have done. And this is not the first time this has happened. Lord, kindly take this, my Lord, so that once and for all, my Lord, this is decided. And, my Lord, I-PAC, whose premises is searched, has not filed any complaint or even petition or any proceedings that my privacy was invaded, etc. He could not have, because it's a statutory search under section 17, but he has no complaint. But everyone, my Lord, is fighting. Yesterday, my Lord, there was a petition filed by the party, the Trinamool Congress. And my learned senior friend, my Lord, appeared, Mr. Raju, and he said,
What are these photographs we have filed?
Yes.
yes, the staging of dharna, etc. Surrounded by the officers, my Lord, which they ought not to have been there.
Is this incident or some other incident?
This incident. These are the colored photographs, my Lord. You have not placed colored photographs. I undertake to place colored photographs on record.
There is some
Kindly have
color,
colored photographs.
some color, some black and white.
No, my Lord, my apologies, my Lord.
No, there are colored also.
Yes, my Lord, these are, this incident.
81, 82, 83 is colored.
In a lighter vein, Millet, some truth is colored and some is in black and white.
In fact,
There is nothing in lighter way.
Light vein. In a lighter.
This is everything very serious.
Smile. We are
I'm
need to respond. Don't go to anger.
smiling, but unfortunately, it's
After all what you have said.
we listen notice, Mr. Sibal, this is very serious matter.
yes.
So we have to examine this.
I'm sorry?
Sorry, mic was off.
Yeah.
We are issuing notice
Yeah.
and we want to examine this. This is a very serious matter.
We have, your lordships will hear us, Mullahs, before doing that.
Yes, please.
Yes, Mullahs. I just want to, Mullahs, let me first clear the air. Mullahs.
Yes.
Mullahs, who is I-PAC, and I'm sure they know about it.
I'm sorry, just because there are two, my
I'm
Lord.
appearing for respondent number 2.
And I'm
Who
for
is
one
the
and
chairman? Who is the chairman of the Trinamool Congress?
I'm for one.
Right.
The Chief Minister
And the police department.
happens to be the Chief Minister also.
Happens to be,
Yes.
yes, but I'm appearing as
Yes.
chairman of the.
Chairman is never
If you don't please, I did not
only a
interrupt you,
minute,
sir.
only a minute, when you say
I
chairman,
did not.
chairman of a party
Do
is
not-
never accompanied by the Director General of Police.
Allow me, sir, to argue before.
My learned will not decide who we are appearing for with great respect.
How will he decide that?
Mr. SG, please allow them to argue.
No, certainly.
Allow us to argue.
No, I didn't know who appears for whom, therefore.
Yesterday, this has been done by your.
Yes, yes.
But we'll come to the issue, according to me, is maintainability. Your lordships will have to decide that the High Court cannot hear this petition for reasons that I'm sure your lordships will give. And if the High Court can hear this petition, then why should your lordships hear it?
No, we are very much disturbed with the way High Court has been almost
No, the hearing took place yesterday, Maharaj.
yesterday, but
Yes,
what happened?
yes, but that's not going to be repeated. That's not going to be repeated, Maharaj. The question doesn't arise. If it took place yesterday, it will take place tomorrow also.
That is my learned
So
friend.
your lordships will have to now assume that the High Court can't deliver justice. Fine, but I'm not saying don't. But Maharaj, your lordships will have to say that, Maharaj.
You cannot put words into our mouth.
No, I say your lordship.
Assume and what we will not assume
It's
is
your
our
lordship.
business.
Of course.
Mr. Sibbal.
Of course, but I'm not saying, Maharaj, your lordship.
Please argue your case.
I'm going to argue, Maharaj.
What we will.
My argument at the initial stage is
please proceed
that
with your argument.
this matter should be heard by the High Court. Because the High Court is the court which has the 226 jurisdiction. It will hear the matter, render findings on the basis of whatever they are arguing there, Maharaj. We have a right to appeal, and then we can come to this court. That's the hierarchy of courts, Maharaj, and they are now filing parallel proceedings, not wanting to go to the High Court. And their argument is on the last day, that on the 9th of January, there was a ruckus, and therefore proceedings could not take place, which is correct. And then on 13th of January, the Chief Justice passed this order, and then yesterday a hearing took place, and the hearing was peaceful, Maharaj. There is nothing to assume that the hearing cannot take place, Maharaj. That's point number one.
Yesterday, Mr. Mehta's client sought time, saying that we have filed in Supreme Court.
Yes, yes.
High Court, can I finish please, sir? So the High Court said, we are adjourning it sine die, with liberty to come back the moment you think the Supreme Court is over, etc. So yesterday, without any ruckus or any involvement, they sought adjournment specifically in the statement, which is why the yesterday order was passed. That's only a fact which should be noted by your lordship, and they said that the matter is coming today.
Correct. Now, Maharaj, on the contentions on facts that he has made.
Yes.
Maharaj, I-PAC, we all know, Maharaj, is an entity which takes care of the elections in West Bengal. A formal contract has been entered into by the party with I-PAC way back in 2021. And I assume, Maharaj, that the ED knows about it.
So elections in West Bengal are conducted by I-PAC or by the election?
No, all the material. There's a confidential material for the purposes of this agreement. Confidential information shall mean any and all information, including but not limited to sensitive or non-public information of any nature whatsoever. There's a whole series of data, of documents, of information, of facts. All that is confidential and it is kept there. And I'm sure that the ED knows about it. He knows about it. So when they went there, they knew that there's going to be a lot of information in respect of the party, the candidates, what is happening, what is the program, where we're going to go, what we're going to do. I'm sure they knew about it. So the first question that arises is, why was the need to go there in the midst of an election? Why was the need to go there in the midst of an election? Now, Maharaj, in the coal scam that we are talking about, Maharaj, the last statement in the coal scam was recorded on the 24th of February. 24th of February 2024. What were they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026? And he's saying we want for what? SIR for what? It is all the information that's in the computer. Once you get possession of that information, how are we going to fight the election? So, Maharaj, which is why the chairman, the chairman has a right to go. It's the property of the party. So the chairman then went, because they went to the house of I-PAC, the individual Pratik Jain, in the morning, in the morning, at 6:20 in the morning.
Yes.
ED went at 6:20. Chief Minister only came at 12 o'clock, Maharaj.
Yes.
And went away at about 12:15.
They collected everything and went.
Maharaj, this is, you can make any statement you want to make, Maharaj. there is a provision in the BNSS which says that 105. And the lies will be demonstrated if they show the video. Take 105 of BNSS. We are also very disturbed, Manas. Extremely disturbed as to what is happening. Why should ED Mullers wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. The process of conducting search of a place or taking possession of any property, article or thing under this chapter or under 185, including preparation of the list of all things seized in the course of such search and seizure and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchman out to you. This is very unfortunate, Malas. And that's why, in a matter of this nature, Malas, and I'll come to the law a little later, Malas. This is just to create prejudice. Now kindly come to the Panchnama. 66, Malas. I'll show you. Page 66. Malas, kindly come to 66. The V Abhamana in Panchas, your worship sees that? And kindly come, they show that search was conducted. Now kindly come to 68. Yes, kindly see. During the course of the search, so-and-so inquired about the ongoing proceedings. At 12:05, the search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings. At around 12:15, took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices. Contradicted by their own Panchnama. An iPhone. She took the laptop which would have the party information and she took their personal iPhone. That's all, nothing more. And then see for third paragraph. The search was proceedings commenced at 6:20 on 8/1/26 and concluded at 2:50 on the same day. The search was conducted in a peaceful and orderly manner, and no damage to any person or property was caused during the search. The entire proceedings were conducted in the presence of the lady staff and whatever. There was no obstruction. And signed by ED. So where is the government in the petition is contradicted by their own Panchnama. Now, what's interesting is there's another Panchnama at 73, because then they go to the other office, which is at Salt Lake.
Another party office.
It has party material, election material, which you are aware of, which is why you went there. It is a completely mala fide act on the part of the ED to disturb the process of election and to gather as much material as they can from the office which has all the material, which is through a contract, which contains all the confidential material. Now kindly come to see the second Panchnama. 74 bottom. During the search proceedings, Ishant Taneja Pavan Verma so-and-so and other employees joined the search proceedings. They were also explained the purpose of the visit by the authorized officer. Meanwhile, Shri so-and-so joined the search proceedings. He also offered personal search. Officers started the search proceedings in our presence in a peaceful manner. Nothing was seized. Nothing was seized there. Nothing was seized here. And from the premises, and no data backup was taken by the team of Director of Enforcement. And the search proceedings concluded at 6:45 p.m. on 8/1. Documents available in the different sections of the premises were not mingled with each other, and the same was left in a proper and orderly manner. These facts were duly acknowledged. That's it.
Contrary to what you are submitting.
I'm sorry?
They had the intention to collect materials from your party office, they would have seized from.
They will just photograph
They
it.
didn't seize anything.
They don't have to seize it. They can photograph.
anything.
They can photograph it. They don't have to seize it. But your lordship
Their
knows.
Rajnama says they have not recovered anything. If they had
Well, why did they?
any intention
Malaj, what?
of seizing your material belonging to your party, they would have seized.
We are not discussing.
They have not seized.
Malaj, these are facts which will have to discover, which will have to be dealt with, Malaj, in a writ petition.
We have to examine.
Malaj,
You file counter, we'll examine.
no, Malaj, I just.
No, you cannot restrain us from issuing notice.
I'm sorry, of course I can't, Malaj. I can persuade your lordship, that's all. That's what I'm trying to do, Malaj.
Yes, please.
I'm only trying to show you,
Yes,
the Panchanamas certainly demonstrate that there was no untoward things that happened, both at the residence of Jain as well as in the office of I-PAC. Kindly have a look. So the Panchas, Malaj, and the Panchanama doesn't say anything of that sort, Malaj?
Yes, yes.
Right. Now, the other question, one question is, Malaj, and I told your lordships on 24th February 2024, Malaj, the last statement in this coal scam was recorded.
Yes, yes.
Then why was there the need to go in
That's wrong,
2026?
factually wrong.
I have got, you've got it. I've got it here. Why do you say it's factually wrong?
From
That's
the record
here.
of the investigation.
No, we have it.
Last instance.
We have it here. 23rd of February.
We are conducting the
23rd of February,
No better.
you have given these details to us. Your petition, you say that 23rd February, Mukesh Thakur claims he transferred the money to Goa at the request of Jitendra Mehta, a financier of Oxford. That's it. After that, no statement. It's your petition.
That is at page.
Para 12 itself, page 104.
We don't
Just read it.
all evidence at this stage, Manoj.
Ari, you have your,
Recorded
I'm taking your
in
petition.
December 25.
Again, you are interfering. I'm taking your petition.
Pages.
Well, kindly come to page 8.
Pages is.
F.
Page F.
Yes.
Is.
S. Okay, I'm sorry.
Which one was it?
That you can read.
Character of information.
Yes, you can. CBI furnished CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date, 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from 2020,
26.
that means 2024, why would you were doing nothing? Suddenly in 2026 you find material?
On the lighter when what Mr. Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, my lord.
That's why this relates to Goa.
That ongoing election. Which election?
Solicitor, you are such a good person. Have the patience to hear us.
My learned friend disarms me.
Well, you're right. There is no election in Goa.
This is not Goa, this is Bengal.
No, this is where Goa, money transfer to Goa.
My learned friend said during election, why did you
During
go for
election
third?
in West Bengal.
There is no election in West Bengal.
Oh, I see. Well, if this is the level of knowledge, Maharaj, that emanates from the solicitor, there's nothing I can say, Maharaj. That there is no election in West Bengal. I'm sure it does.
He's yet to be notified what he's saying.
He can say that, Maharaj. He's a very precise lawyer. He's very careful with his words.
I am, Malord, therefore I am saying there is no election. Your premise is wrong.
Absolutely, there will be none.
Malord, only one line, Malord. Allow me to interrupt. Malord, if the ED officials go to their party office, it's not a party office, it's an office of a strategist kind of according to them. What would a normal person do? Please give me a minute.
Can you? No.
This document have two sets.
One second.
One my party thinks and another maybe else.
1 second. Wait.
Another you can go, but allow me to take my party details. This you have nothing to do with his party details.
Solicitor seems to have
Just takes everything which is shown in the media with files and everything that I have taken everything. Otherwise, if there is a scrutiny, say no, this is my party.
Everything that he says has to be accepted, rather than why are we here? Maybe because he keeps on interfering, says what he wants to say, as if this is the gospel truth. It's not fair. It's not fair on us. Now, kindly see page 38.
1 minute. I am there in the second petition.
No, 1 second. Allow us to finish.
It is not to be seen.
Correspondent argument, 2 minutes at
We
least.
are arguing only first petition.
Very well.
I'm arguing only the first page. Now, kindly see page 38.
Petition you will be allowed to argue.
The second is,
Don't worry.
yes.
Kindly see page 38. Kindly see page 38.
38.
Yes.
There is some circular issued by the Honorable Chief Justice about time schedule.
Yes. You must
Should
fix it.
apply to
Yes, and interruptions, but both.
motion hearing also.
Both
To
hearings.
regular hearing.
Yes, but the Honorable Chief Justice also should issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also
Malaj, that the CBI should not be leaking information and
Yes.
the ED should not be leaking information.
Yes.
To journalists of their liking. Therefore, there should be a ban on that also.
Yes, I'm ready to show, Malord, what I've stated.
You can show it. You can show it.
This is not the
Narrative building
That's why
should also be-
my learned friend always, he's very upset at the fact that I do some program with us. He seems to mention, it's his every matter he mentions this, Malaj. You should watch it a little more, you'll understand a bit.
Program. Don't discuss matters. Don't discuss matters which were.
I'm entitled to.
I have not seen
I'm
any.
entitled to.
No.
I'm not entitled to. Well, he knows about it. He
Mr.
said-
Mehta is increasing the circulation of this program now significantly.
No, it is.
Without watching it himself.
Malaj, page 38. Let's move on to the matter.
Yes, 38.
Yes. Now, what are the offences, Malaj, that are alleged?
Yes.
Yeah, it's all 37, but the offences are all these offences: abetment, criminal conspiracy, voluntary causing hurt to public servants. No such thing. It's on the face of it. In their own petition. Wrongful restraint. No statement of that sort. Wrongful confinement, force, criminal force. What is all this going on? 130, assault on criminal force, obstructing public in discharge, omission to assist public servant when bound to give assistance, disobedience to order duly promulgated, theft in dwelling house, theft after preparation made for causing death, hurt or restraint, robbery, dacoity, criminal trespass and house trespass and house breaking, house trespass in order to commit offence, causing disappearance of evidence, destruction of documents. What is all this? This is all contrary to what is in the Panchnama. How can all this happen? And Malaj, all this has to be done how? Under 66(2). Under 66(2), if there is any offence, it has to be reported to the investigating agency of the state. Your Worship, no 66(2). I'll read it to you. How can all this happen in a writ petition in 32? That is 66(2).
66.
66.
We have gone through that.
Sorry, of PMLA.
PMLA, I
Yes,
said,
yes.
866.
Yes, no. 66(2) of PMLA. I read the offences to you just to indicate that all this cannot happen in a writ petition.
No, it has not happened in a writ petition. It has happened there.
No, he is saying these offences have been committed and therefore they have to inform under PMLA if the director or other authority, just read Manoj. If a director or other authority specified in subsection 1 is of the opinion on the basis of information or material in its possession that the provisions of any other law for the time being enforced, that is IPC, these are IPC offences, they are contravened, then the director or such authority shall share the information with the concerned agency for necessary action, which is the state agency.
investigation is.
So, Malad, so what they are saying is these offences are committed. They say now you must charge them with these offences. We have filed a writ petition, whereas under the statute they have to inform the agency of the state that such offences have been committed. Please investigate. They can't ask your lordship in an Article 32 to do that. And they are choosing the agency which is being accused by us for mala fide searches. And then apart from all that, and I'll let my learned friend take it forward, Manas, apart from all that, Manas, the question is, why should the High Court not hear the matter? High Court is not disabled to hear the matter.
I'll take
So we'll take our submission.
I'll take
Only one.
Mr. Mayor, please allow correspondent three minutes.
Not on the merits. But one response to Mr. Sibbal, a very respected. I personally, you know, I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibbal.
It's also
everyone.
It's also against
who appear.
Yes.
In the matter should not give press conferences and give media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. In principle, he should have no objection because he knows that that's not the law. Once a judgment is delivered, it's public property, and this court has said that once it is public property, it can be discussed. He knows the law, but he doesn't want to reveal that he knows the law.
No, my lord, the incident in question, there is no judgment in law and narrative building.
No, my learned friend is wrong. There is a.
I leave it at that.
There is a.
No, can I have minutes?
I leave it at
3 minutes. I heard my lord's minutes, but my lord's.
No, we have the entire day, about second half bench is cancelled.
I mean that matter, Manoj, it was mentioned without telling us. That bench, Justice Amanullah and your lordship.
I do not know your loss, but your advocate on record was informed that he was present.
My lord is saying something. Let me
was present.
It was cancelled by the bench, by the court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us after.
No, my lord, we mentioned with presence of his advocate on record,
Anyway.
with consent.
What Mr. Singhvi
I
said.
can apologize.
In fact, the court said that we'll fix a date later.
He should have been heard before cancelling the bench.
No, I should know.
Understand why?
Yes.
They have long
Lord, he
conflict
can,
to do and they should
Understand
put
can
on
be
it.
deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he
let me
said,
come.
2 p.m. bench, that he should have been.
I know this is
heard.
Amanullah bench. Anyway.
That it should have been
Let me
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please, please.
Because those people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was
Yes,
complaining.
yes, you are right.
Anyway, Willis.
You are right.
Now I am going to make 3 or 4 points in less than 2 or 3 minutes, Willis. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where, Manus, it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it, Manus, strongly, both today and in any eventual hearing.
You are appealing for state of.
I am for 1 and 3, state and
of
police,
Bengal.
state and DGP. 1 and 3, he's for 2. Point number 2, Manus. I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law. Because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship will take my word for it. The prayers are virtually identical.
Here in High Court and
In
here.
High Court and here. Lordship need not waste time seeing it. Lordship will take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding two horses.
It happened at
No,
all.
Malas, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold brief that should.
Today it is this high court, tomorrow the
Malas,
another high court.
sometimes Malas, emotions go out of hand and they can't be controlled. That, Malas, please don't misunderstand me that I'm not understanding my lord's concern. And that, Malas, I don't think anybody will hold a brief. Perhaps, Malas, emotions go out of hand and we are not able to control. But the relevant test is yesterday.
It should not go out of hand regularly.
No, no.
In an orchestrated manner.
And then on 9-1, again, emotions go.
Now, Malas, sir, may I just say? We are now, Malas, talking of R1 and R3. I am saying this, Malas, that the relevant date for considering forum shopping is yesterday. I understand, I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is forced to pass such an order, Malas? Anyhow. It is not that you are getting this date yesterday because of that ruckus. Kindly give a copy, no? Why don't you give a copy? One copy. So, Malas, in effect, the High Court is told, I am riding two parallel horses. I am telling your lordship I am riding two parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, Malas, in Committee of Courts and Superior Court and all that, Malas, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am, Malas, on the conduct. So this is forum shopping. I again take the strong preliminary objection. My third submission is, Malas, the Panchnama, which has been read. Malas, that has been read, I am not repeating it, but just note the relevant words, only the operative words, 3 lines, which are seen, Panchnama, which has been read already. Been read, but just the relevant lines, Malas, at 66 to 69.
66?
Yes, 60 to 69. These words are important. That's my third respectful submission.
At page?
Malas, at page 60, this particular portion is which page?
68.
68. You also use the first file.
Yes.
If you also just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments were heard.
May read the 2 paragraphs above.
What peaceful means peaceful from their side. They mean to say
2 paragraphs above what my learned
it is side, not from your side. It is not from
I'll
your
read
side.
whatever you want me to read, I'll read it, Malas.
not the relevant section. Let him.
They have done it peacefully.
No, Malas,
I can read the 2
the
paragraphs.
previous para which he's asking
2 paragraphs
to
of
face,
by
respond
may not
Mr. Raju, please.
Let him read.
It is not denied by our.
Take Mr. Raju that what he is reading.
We didn't interrupt once even, Malas.
Yes,
It took a long time.
Please interest me.
Mr. R2, Mr. Sibbal, has admitted that the CM was, well as the president of the party was there. So what is so great about this para? This para says that so and so time, so and so Miss MB took possession of the material, etc., etc. That's all. Where nobody is denying that she was there. Now, I am, these are derailment. I am at a different point. I am saying that with this Panchnama, what you are projecting in the petition is either clearly false or your Panchnama is false. That's all I am saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to mildly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. I mean the day before the event happened. I may have been wrong, I may not have heard you correctly, in which case I am wrong. Well, it's the first and only intimation came from a casual email at
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? Have you heard my sentence? You realize? You don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. That's why I say that, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was beforehand informed. In the middle of balance, the persons are there, some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, Balas, that the question is, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, the moment we come to know, we have to move. Well, in the light of this, the Lordship may consider, I leave it to my lords, that we put in, if your Lordship is so inclined, without notice also we can put in a reply saying these points. Otherwise, leave it to my lords.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No, I will put in these things, your Lordship wants me to put in.
Legal things should be
There
done.
are other respondents also.
Should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
Sorry.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the
No, Mr. Raju wants to argue the second petition.
first petition.
First petition, respondent 4 and 5.
5, yeah. So I just have a very small point. Your Lordship may just consider that the appropriate order, perhaps in a case or a situation like this, your Lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The Lordship wants to reinforce, because the Chief Justice's directions are very clear, is proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering effect which persuades this court to issue notice under 30. So let us see what happens, my lords, on the adjourned date or the next date as far as the 226 is concerned. If that proceeds smoothly, as it will, I mean, we expect that it will, that's a much better way of going about it, my lords, rather than this. I would respectfully submit that statement, at least at this point.
Yes, Mr. Raju.
Well, there are several submissions that I have to make. The first submission is the recording of an FIR only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumar is very clear. No inquiry is required, no accused is required to be heard. The defence is not to be considered at that.
About which FIR?
I am asking for the FIR which I am asking to be registered in CBI investigation.
Oh, yeah.
For that I am making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abandoned caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one, my lord. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offence of cognizable offence has taken place because an offence of theft. I have pitched my case a little higher. It is not only theft, it is robbery and it is dacoity, because more than 5 persons were there. Some policemen were armed and there was wrongful restraint. But forget that. Simple case of theft, which is a cognizable offence, is made out on admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offence, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari? Or
Yes, read.
Give me Lalita Kumari. Come to that. So kindly,
Continue.
I'll not take much time, but I'll only make, kindly have a look at para.
You argue, we have no difficulty.
Kindly have a look at para 120 onwards, conclusions.
Yes.
5.
Para 5.
120
Para 120.
at page 61. 120.1. The registration of FIR is mandatory. Kindly note my mandatory under section 154 of the code. If information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Para 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That is not the scope of registration of FIR. You have to look at the averments made by the informant, in this case in the petition, and if it prima facie makes out a case of theft or a cognizable offence, FIR has to be registered. Therefore, whatever they are saying, we went there because of a party document, which is wrong. Otherwise, no FIR would be registered. The entire purpose of the scheme of the CRPC would be frustrated. This is number one, Manoj. The second is, ordinarily, I have to go to the local area where the offence has been committed to get the FIR registered. But this case stands on a different footing. Your Lordships have permitted deviations from the normal rule. Why the local police should not be permitted to investigate? Here, the Chief Minister is an accused. She is the person who has personally committed the theft. This theft was committed in the presence of the Director General of Police, who could be an abettor. It has been committed in the presence of the Police Commissioner of Calcutta, where the offence has taken place. So, head of the police in West Bengal is accomplice as far as the offence is concerned. Police Commissioner is an accomplice, and she is the Home Minister. So, no FIR, if it is registered, even if it is required to be registered, will be inquired and investigated properly. Now, the law is, kindly have a look at 3 judgments. In this case, if the highest authorities are involved, then the CBI investigation is to be ordered. But kindly have a look at, one is K.V. Rajendran versus Superintendent of Police, 2013, 12 SCC 480. 480.
480. Para?
Era would be 17. Where they say if the
70.
17. It is extracted at page 31 of my petition, Manoj.
Page 31 of your petition.
Yes, of the first petition also, my lords, we can have a look at it.
In
In view of the above,
page 480.
page 31 of my petition, my lords have got it?
481.
480 para 17, my lord.
1312.
I can hand over a copy of syllabus.
No, we have
In view of
para 17.
7.
In view of the above.
In view of the above, the law can be summarized to the effect that the court should exercise its constitutional powers for transferring an investigation from the state investigative agency to another independent investigative agency like the CPI only in rare and exceptional cases such as where high officials of the state authorities are involved or the accusation itself is against the top officials of the investigating agency, thereby allowing them to influence the investigation, and further, that is so necessary to do justice and instill confidence in the investigation or where investigation is primarily found to be taken. This is at the stage of investigation, but prior thereto also it can always be exercised. Then kindly have a look at the second judgment, my lord, 2014, 8 SCC, page 682, para 86.
14.
2014, 8 in SCC, page 682.
Last but one page, but no, just for easy reference. Last but third. Yes, sir.
It is the para 86, Supreme Court page number is 736. The criminal, it starts like the criminal justice system mandates that any investigation into the crime should be fair in accordance with law. So if it is investigated by the accused or somebody subordinate to the accused, it can never be fair.
Yes.
In accordance with law and should not be tainted, it would be tainted. It is equally important that interested and influential persons are not able to misdirect or hijack the investigation, which would be the case if the local police are asked to investigate. So as to throttle a fair investigation, resulting in the offenders escaping the punitive course of law. These are important facets of rule of law. Breach of the rule of law, in our opinion, amounts to negation of the equality right under Article 15. Therefore, my lord, I can come here directly because otherwise my right under Article 32, fundamental right under 14 would be infringed. Therefore, I can come directly to this honorable court, even under 32. No need for me to go before the High Court. Then, my lord,
Why can't you continue in this court?
I'll tell my lord why.
You answer it after we come back post lunch.
Very well, I'll answer.
Articles 131 to 139, which define that jurisdiction. Please mark, my lord. Article 32 provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon, refuse to entertain applications seeking protection against infringement of such rights. No similar provision is to be found in the Constitution of United States, etc. Lord, here the officers are also before your lordship seeking their Article 21 rights, because there are FIRs filed by the local police and they are threatened with, my lord, their freedom under Article 21. Apart from, my lord, my lord, jurisdiction, my lord, on behalf of the victims of money laundering, my learned friend.
Kindly have a look at Article 226, sub-article 4.
226.
226, sub-article 4. The power
Yes.
The power conferred on the High Court by this article shall not be in derogation of the power conferred on the Supreme Court by clause 2 of under Article 32. So this, according to me, is the issue. 32 powers are protected even under 227, as by the Senior Solicitor General has said, it itself is a fundamental right. There have been cases where the lordships have transferred investigation to the CBI in exercise of powers under Article 32. I may give one or two judgments by way of illustration. I see. Can we have a look at para 80? And 82.
80.
80. This has been done in exercise of powers under 82. I may just leave it. But in a given case, your lordship may come to a conclusion that it warrants not only investigation by the CBI, but it warrants investigation to be done outside the state. In a given case, if it is to be done outside the state, 226 powers cannot be exercised. One judgment, Mother, to para 89. All right, I leave it to that extent. Therefore, now as far as the
Yes.
ED officials are concerned, but 4 FIRs have been filed against them. Kindly have a look at section 67 of the Prevention of Money Laundering Act.
Which provision?
67. No suit
Yes.
shall be brought in any civil court to set aside, modify any proceedings or order made under this act, and no prosecution, suit or other proceedings shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So the such proceedings were done under good faith under this act. Therefore, the prosecution, the FIRs are not maintainable. They hit by the bar under 67. Despite that, to put pressure on us, these 4 proceedings have been filed. Therefore, I have read separately for stay. Order of stay may be passed, notice may be issued, and the matters may be heard. So all that I was.
We are praying for stay of the FIR against us. The ED officials are facing FIR filed by the local police. These are the FIRs. We have made the averments, we have given the details, and we have prayed in prayer F.
Yes.
And they are constantly filing new FIR. So that has been a pattern, we have seen. Page 126 is the prayer clause.
Let us see the prayer. Prayer is.
Page 126. page 126.
No.
E. Capital.
Main matter, page 46.
126, my lord. Main relief, your lordship, yes. Issue a writ of mandamus directing the. Sir, your lordship wants the entire prayer clause, my lord, to be read or
Just a minute.
the interim?
What are your, yes, interim.
Interim is page 126. My lord, where right now, my lord, I would be subject to a lordship, my lord, being persuaded, saying for E. In the meanwhile, your lordship gets direct stay of the FIR number so and so registered at Shakespeare Sarni, FIR number so and so, and any other FIR registered against any officer of the Enforcement Directorate with respect to the searches conducted on 8/1/26 during the course of investigation of coal scam, etc. So we have restricted our prayer, my lord, to this incident.
What is this past interim direction commanding the respondent to preserve deposit to provide a CCTV cameras is to?
Yes, my lord, that should be preserved, my lord. Let it be with the registrar of this court.
No, right now you are paying for E only.
E. But my lord, if my lord, your lordships are persuaded, my lord, C also, my lord, A. Interim directions commanding the respondent to preserve, deposit and provide the CCTV cameras and storage devices containing the footage of both the premises search on 8/1/26 as described, and not to make any deletion.
Just take. In these two writ petitions, referred by the Directorate of Enforcement. Oh, yes, in the first writ petition, the petitioners are Directorate of Enforcement and its Deputy Director. Whereas in the second writ petition, the petitioners are
Then the assistant directors and the persons who were party to the search and they've been named in the FIR as accused.
are the officers of the Enforcement Directorate.
One is the IO of the case.
Enforcement Directorate against whom?
Nobody is named. I'm sorry, nobody is named.
Huh?
So they are not named, but they would be.
They went for the search, and the officers who conducted search without naming them are the FIR.
Who had gone to the premises, subject premises, in course of investigation conducted by the ED. Learned ESG, appearing for the petitioners, would draw our attention to the series of events which has led to the filing of the present writ petition. According to him, the ED was investigating a scam amounting to rupees 2,742.32 crores since the year 2020, and in course of the investigation of the said scam, intelligence was received that about 20 crore of proceeds of crime from Kolkata to Goa was transferred through our Kantilal firm, and which has eventually channeled into I-PAC's operational framework by being handed over to persons executing the work. executing its work. Armed with authorization to carry out search and seizure proceedings at the residential premises of Mr. Prateek Jain of I-PAC, the officers visited his premises on 8/1/2026. Visited his premises, amongst other premises, on 8/1/26. And when the search was going on, the Manoj Kumar Verma, IPS, the Commissioner of Police, Kolkata, first entered the premises. Dr. Sri Priyabrata, IPS Deputy Commissioner of Police, Sri Manoj Kumar Verma, IPS Commissioner of Police, Kolkata, entered the premises, and thereafter the second respondent in WP number so and so, the sitting Honorable Chief Minister of West Bengal, Ms. Mamata Banerjee, also entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. He would submit that this is not the singular incident where Honorable Chief Minister has entered the premises under investigation by the ED, under investigation, as on an earlier occasion when the CBI was investigating an offence, a similar event has happened. Therefore, there is a pattern of interference with the investigation carried on by the central agencies. According to him, the materials collected by the ED officers were taken away by the respondents in an illegal manner, and thereafter the West Bengal police have registered FIRs against the officers of the Enforcement Directorate. Now, SG would submit that in a situation like this, it is difficult for the central agencies to carry on investigation which has connection with a huge scam running into so and so, 2,700 so and so crores. Learned Counsel would submit that true it is that the petitioner ED has prepared a writ petition before the Calcutta High Court, but when the matter was to be taken up for a hearing on 9/1/2026, the legal cell of the Trinamool Congress sent message to its member on WhatsApp calling them to assemble in the court, and thereafter what has happened in court has been recorded by the learned judge in its proceedings dated
Page 121. 121. Order is
dated 121, which is reproduced here under. Para. On the above basis, Learned Counsel would submit that Learned SG would submit, firstly, that the present is a serious matter which needs to be examined by this court, and secondly, the High Court is not allowed to proceed further Full stop. According to him, comma, since high police officials of the state government are involved, comma, it would be appropriate for this court to examine the issue in the larger interest of justice and to set and full stop. Learned ASG Sri S.V. Raju, appearing for the petitioners in the other writ petition, would submit that recording of FIR in a cognizable offence is mandatory in view of the law laid down by this court in Lalita Kumari 2014 volume 2 SCC page 1. According to him, when the Honorable Chief Minister and the Director General of Police are involved in the matter, it cannot be expected that the police officers subordinate to them would conduct the investigation in a fair manner. He would submit that the present is a case where the offences committed by the respondents would be investigated by the CBI. He would next submit Sri Kapil Sibal, the Senior Counsel, appearing for the respondent number 2 in first petition, and Sri Abhisakhni Singh, Learned Counsel, appearing for the respondent number 1 and 3. Yeah. 1 and 3 would submit that the present petitions are not maintainable. He would submit that there is a pattern of interference by the ED in the name of investigation exactly at the time when elections are due. They would submit that when the matter is pending in the High Court, the present petition under Article 32 of the Constitution of India may not be entertained. Taking us to the materials on record, particularly the Panchanama available at page 66, it is pointed out that nothing material was recovered during the search and the seizure. It is also argued that the local police officials were not informed by the ED before initiating the search in the morning of 8/1/2026. Sri Simple would particularly submit that the respondent number 2 had not gone to the place of incident in the capacity of the Chief Minister, but C, being the chairman of Trinamool Congress, had gone there on information that certain unauthorized persons have entered into the premises of Mr. Pratik Jain, who have been entrusted with party's election work. According to Mr. Simple, there was nothing available in the office of I-PAC except some election related documents with which ED has no concern, and they should not have entered the premises. Full stop. The symbol would also submit that the respondent number 2, being the chairman of the TMC West Bengal, it's a national party, TMC is a jet protectee, is also a jet protectee. This is your argument. Mr. Singhvi will submit it. Singhvi will submit it. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Sri Shyam Devan, learned senior counsel, appearing for so and so, correspondent number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected by protected under the shield of law enforcing agencies of a particular state. According to us, larger questions are involved, have been raised and are involved in the present matter, which, if allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether in the shield of taking shield of its party activity, the the agencies can obstructed in carrying out their investigating power in a bona fide manner. Issue notice to the respondents. Let counter be filed, counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week. Within a week.
It's at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we will preserve all the material. If it takes longer time because the digital
Not
evidence.
preserving, Madam. Your losses make
Yes.
no issue on that.
Yes,
Not
in 2 weeks.
2 weeks.
Post the matter on is 15. Post the matter on 3rd February.
Prayer A and E.
Full stop, full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition and the CCTV cameras and storage devices containing the footage of nearby areas. Now what it is to this investigation and the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3 of 26, 4 of 26 and 5 of 26 registered at electronic.
There is one more, 7 also, my lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed
7 of
subsequent.
26 registered at electronic PS, Vidhan Nagar.
No, there are two from Shakespeare Sarni.
Just name the police station properly.
No, it's in E. E has, my lord, the police station, page 126E. 2 are, my lord, from Shakespeare Sarni and 2 are from electronic PS Vidhan Nagar. The index, my lord, in the present.
In just IA.
Yes.
Direct.
It's a document compilation.
Is also direct that FIR number 3 of 26 and FIR number 4 of 26 registered at police station Shakespeare Sarani and FIR number 5 of 26 and 7 of 26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this?
So we will not be aware of.
This is
We
not
do
like
not
a
know.
blanket order.
There should be clarity in our order.
Yes,
Can't
sir.
say that any other this
No, I understand.
this is not proper.
Great.
Whereas I have one request, just Lordship considering. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
So I'm only saying, investigation without any coercive steps.
Mr. Singhvi, you understand the delicacy of the matter.
But equally,
If you proceed,
both sides.
you proceed with the investigation in any manner,
Without
it will be
any
difficult,
coercive
but
steps.
then we will.
Without any coercive steps.
No, my lord,
In any manner.
that will not.
Secondly, if your Lordship is granting a stay on investigation, then let us have more time to reply, because then there will be a complete stay on investigation. Let us take out all.
No. 15
There has
days
to
is
be
enough.
more.
What more you want?
Maybe 3
In fact, this order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Yes,
Because
be a little
nowadays it is aired, everything.
Now that
Then
it is-
everybody will say that court has
Now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
my lord, the IA for addition of party, for chief secretary and others are being joined. And my lord, prayer for
Chief Secretary.
suspension. No, suspension power is with the chief secretary.
That's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer, my lord.
Let's,
strongly opposing this kind of.
Notice may be issued.
let counter to IA number so and so
Yes,
may also be filed.
yes.
Not even listed, my lords. Not even listed.
No, it's given, my lord. Copy is given.
It's
Therefore,
not.
I have tendered
These
it.
are the strange
You
procedure.
kindly list it tomorrow, my lord.
Whatever
Let
it
them
is.
file a reply. I may not get the relief today.
Just not.
You already file counter. We are not saying anything. No, passing no
Yes.
orders on that.
We'll file counter.
Passing no orders on that.
Malad, if we filing counters in applications, then the main matter, Malad,
There are only two main matters.
There's so many matters there.
No, only one matter and application.
Let's let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
You
numbered.
file before the next date of hearing.
Yes.
Yes, next.
Item 28.
Right.
हमारे notes का इस production है.
G.
22, corrected. 20 is corrected. 20 is connected.
Yes.
It says something vast.
29.
Yes, next.
Well, it's in this matter, this is for anticipatory bail. Now, he has no criminal antecedents whatsoever.
You impersonated this.
That is the allegation on the basis of statement which is made in police custody. Now, between
You have said in one of the ground
yes,
that settlement agreement
that's right, my lords. We
has
can
been entered into family members of other person with the complainant.
that is on record at page 60. So the money has now been given to the vendee. Page 60.
On the ground of settlement.
Yes. Ms. Tika Devadi, learned counsel for the petitioner, who submits that the petitioner was not named in the FIR, and as a matter of fact, in matter of fact, which is that page?
Page 60.
60 is something different. Bail application.
No.
Where is that agreement?
Page 44. Sorry, I'm so sorry, my lords. The settlement agreement is at page 44.
As a matter of fact,
Council का नाम, the early council petitioner would submit that petitioner was named in the FIR and as a matter of fact.
and as a matter of fact, the complainant and co-accused persons have already entered into a compromise, and the entire amount in question has been refunded to the complainant. So notice, returnable on 10th February. In the meanwhile, petitioners shall not be arrested in relation to crime number so and so, police station so and so, offences under section so.
Very good.
Yes,
What should pass over?
pass over.
Item 1.
Wait, please look. But at the time of issuance of notice, your lordship had directed me to first surrender law and granted specific liberty to file for suspension. This is
Yes, Mr. Sharma, this is an offence of 1992.
That's correct, Lord. I understand that situation.
Now after 1992 means 36 years. He sought to be arrested. Needs to be examined. It's not considering that the offence was committed on 29/8/1992. That is more than about 36 years back. And presently the petitioner is in jail from 18/8/25 after he surrendered before the trial court. We are inclined to suspend the sentence and release the petitioner on bail.
Approximately in the facts of this case, because he has not undergone even one fourth of the sentence.
Therefore, considering the facts and circumstances of this particular case, we are inclined to suspend the sentence and release the petitioner on bail. Accordingly, it is directed that on petitioner's furnishing, therefore, it is directed that petitioner shall be released on bail on such terms and conditions as may be imposed by the trial court.
Very good.
Post the matter, records have been summoned.
No, not yet.
That record of the trial court be summoned and the matter be posted. The matter be listed on 6th April.
Very deeply applied. Is it from my
Yes.
Lords, also passed over item 5.
Password.
Yes, this is that matter where the court.
I have been for the
Only about cost.
notice was issued to the limited aspect.
Yes, yes. If granted.
Yes, sir.
Under the interim order, the High Court has quashed the notice issued by the Additional District Magistrate Hon'ble in so and so ये अपने order में लिखा हुआ है 28/11/25 के order. There are two matters.
Yes, no, same, exactly the same order has been passed.
ये देखिए दो केस नंबर लिखा है एक एसएलपी का एक केस नंबर है एसएलपी का दूसरा केस नंबर ये कॉमन ऑर्डर है ताकि दोनों का एक साथ लिख दिए अच्छा दोनों का कॉमन ऑर्डर ही बनाओ कॉमन ऑर्डर so and so in case number so and so pushed out while crossing the notice under challenge before the High Court a cost of ₹20,000 has been imposed on the state of UP in each of the case, further reserving liberty in favor of the state to recover the same from the concerned additional district magistrate. Having examined the matter, we do not find that the High Court has recorded any finding that the concerned additional district magistrate has passed the order which was under challenge before the High Court in modified exercise of power or due to any extraneous consideration. In such view of the matter, imposition of cost of ₹20,000 and directing the same and reserving liberty in favor of the state to recover the same from the additional district magistrate is not justified. Accordingly, we quash the said part of the interim order imposing cost of ₹20,000 on the state.
What's the question of law that would be left open? Another matters also is that
I have already dismissed that part. That part is already covered in our order issuing notice.
Very well.
Yes.
Deeply aware.
Am I audible? Am I audible?
Yes, yes.
This is a transfer petition by a wife who is based in Kanpur and she's seeking a transfer of the Section 13A petition from Gwalior to Kanpur, which is approximately more than 300 kilometers far. Now, also see annexure 4 of my petition, there was a different matter way back in 21 involving the similar parties, in fact, same parties, which was also transferred to Kanpur from Gwalior. Annexure 4, Malots.
Page?
Malots, page 38, Annexure P4.
Yes.
This is the order of the Supreme Court, Malots.
The order. Then let it go to this same place.
Malots, there are
Yes,
two
Malots.
submissions in this matter.
Yes.
Prior to the mediation, we were informed that they are willing to settle the matter. We took the matter into mediation and they informed us that they would be willing to settle with the amount that we stated. Right? We stated that the settlement should be arrived at an amount of 10 lakh rupees.
Malots,
They now increased
they
that.
never offered 10 lakhs. They initially offered 18 lakhs.
The child is in all.
Just 1 minute.
They have now increased that amount. They went to 30 lakhs just to settle the matter. Now they also have the custody of the child. I am paying, why the order dated, why an order dated?
This is only a transfer petition.
Yes, Malots.
This is a transfer petition, Malots.
Harass us in the mediation.
Malots, this is very unfortunate that a man who is so self-centered, he's hardly bothered about his son, Malots. He's not ready to pay anything. We offered him to create a FD for his son, he refused.
Maintenance is 2024, that maintenance
He's
amount
not willing to pay a single penny for his child.
Considering that on an earlier occasion, this court has allowed petitioner's TPC number 2840 of 22 and transferred HME number 543-A of 2020 from Family Court Gwalior to Family Court Kanpur City, the present transfer petition deserves to be allowed so that the cases pending between the parties are tried at Family Court Kanpur. Accordingly, the present transfer petition is allowed and so with prayers lawsuit. Yes.
Much obliged, Malots.
Item 14.
Yes.
This is a transfer petition filed by the mother-in-law, husband, brother-in-law.
Mother-in-law. Transfer petition by mother-in-law. Idiot.
We all are the petitioners here. A husband, brother-in-law, mother-in-law, age 80 years, and a sister-in-law and a relative is 71 years.
It is from Visakhapatnam to Mumbai.
Please note it. More importantly, that the
why DBA proceedings initiated by the wife should be transferred to a place where the husband is residing?
No, but Lordship, my problem is that kindly see page number 56. We are represented by the lawyer there, but the court learned ACJM
wants you to appear. You appear, husband, others may be exempted.
That's all.
So there is no problem so far that is concerned. This transfer petition appears to be filed on a premise. They appear to be aggrieved only by the reason that they have been asked to appear personally. But if that is the grievance, they have a remedy to file an appeal. Because there is no other ground stated in the transfer petition for seeking transfer. So I stay in Visakhapatnam with my 4-year-old daughter, Malots. It is not possible for me to travel. And 498A trial is already going on there. They are appearing there. They are appearing in this one also through their lawyers.
On hearing learned counsel for the parties, we are not inclined to allow the transfer petition. Seeking transfer of the proceedings under the Domestic Violence Act initiated by the respondent wife. However, we direct that the trial court, that is the 4th Additional Chief Judicial Magistrate, Visakhapatnam, Andhra Pradesh, shall not insist on physical appearance of the respondent.
Well, let's consider saying the other respondents. So the husband can appear, the other respondents will be exempted, subject to what my lord speaks.
Respondent of the relatives of the husband.
That's right.
Unless their physical appearance is mandatory on any particular date of hearing.
Worship, they can join through VC, Lordship.
That's what my lordship says.
The relatives of the husband shall appear through video conferencing on such dates where their physical appearance has not been directed by the court.
Absolutely.
Yes.
Great.
What?
But this,
Yes.
this petition, Lord, caveator is present here. It was passed to. Caveator is present.
Eviction.
From a shop, Lord, in Delhi.
Market.
Please, Lord.
Khan Market.
450.
2017 eviction, 18th March 2017, and you are resisting.
No, I am not resisting, Lord.
Then who is resisting?
I am not resisting. I just filed a revision. That's all. In the Delhi Rent Control Act, there is no provision for an appeal.
Means resisting in a legal way.
Yes, that way.
Not
in any other way.
Yes, yes.
Not under the Delhi Rent Control Act, there is no appeal.
Time, how much time?
Your Worship, just allow me.
You say there was an oral agreement.
No.
To sell.
Yes. No, I've got the material.
Honoring his oral agreement for last so many years.
The material is
not selling it to the person with whom he has oral agreement.
No, may I just Lordship, just allow me about 2-3 minutes, and then I won't take a Lordship more. Lordship, I'll just refer to my written statement where I said so that all these facts that they had agreed to sell this property to a person through so and so. In the replication, they admit it. They admit that they were dealing with this man, but they changed their stance and they said this was only to in order to enable him to change the nature of the property from leasehold to freehold. This is their stand. When the document comes, the document comes, it says permission to sell. I just point that to your Lordship. P2. Lordship may just have P2. Lordship may have P2, and then I'll also it is permission. Lord, P2 is at page 68. Page 68. Lordship may see the title of this. P2, page 68. Permission for sale of shop number 30A, Khan Market. So what they say eventually when it comes in
2010.
Yes, madam. But this is during pendency of the rent petition.
And you are a tenant since?
Since 1975.
It will happen. Out of frustration, the landlord will say.
No, Lord, it's not out of frustration. When they gave it to me, that was the market rate. It's a different matter. Market forces have changed. It's a different matter. Now I'm paying 2.5 through court.
Always happen. The landlord feels after 15-20 years.
So here they want to sell it. Then come, Lordship may allow me to refer to.
You see, this particular area is the costliest.
Yes.
In the Asia, or I do not know where. Some news I have read.
Yes.
This Khan Market.
Lord, now it at one time it was. Now it seems to have lost its sheen. This area has lost its sheen now.
It has not lost its sheen.
It's only now an eating place where everybody goes for the restaurants, more restaurants than.
I do not know whether it is eating or something else.
It's more like that now.
But it is
market
very
is
popular.
famous for that.
It is very popular.
Yes, therefore he wanted to sell
For
it.
multiple reasons it is popular.
Therefore, my lord, the idea was to sell it. And now, unfortunately, under this act, my lord, this is a strange act. It doesn't even have a provision for an appeal. There's no provision.
The only ground to issue notice in your case is that Mr. Siddharth Dave is appearing.
That is good enough, Lord.
For the landlord, leaving all his bail matters and bail matters.
That's why I had to take a pass over. I'm very sorry, man.
And my lord, a caveator got a pass over. That's good enough reason. We've all been waiting. Lordship,
in time 6 months, 8 months.
Lord, statutorily there are 6 months. The court says, I'm not even grant you that. Please leave immediately.
2017, you were allowed 6 months. Several 6 months have gone.
After that, I had a right to file a revision. There was a stay order in that revision. And then I've been paying money as per the market rate.
Now we can allow further 6 months. We can allow further 6 months from today.
No, could your lordship just consider increasing that amount of days? Why? Because it's a shoe shop. I have to sell off.
Amount of?
Of the time.
No.
I have to sell this entire material there. I have to sell this entire material. I'm not shifting to another place.
And
I will shut down the business.
He owns the shop which is next to it.
But I will not.
Next to this shop, he owns a shop which is let out for 8 lakhs of rupees. And I am 2.5 lakhs, he has to shut down this business.
Not.
This is not fair.
There's nobody ready to take on the business.
My learned friend should be fair.
After upon hearing learned counsel for the petitioner and learned counsel for the aviator, we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, considering that the subject premises is a non-residential premises, we allow the petitioner to occupy the same for a period of 6 months from today. Accordingly, the SLP is dismissed and the petitioner is directed to hand over vacant possession of the subject premises on or before today is 15th, on or before 16th of July 2026.
You can pay that amount.
Petitioner shall file usual undertaking before the registry of this court and also continue to pay the monthly rent oblique
It was fixed as user charges, my lord.
user charges
As assessed by the High Court one.
as assessed by the High Court. Yes, next.
And we have 3 minutes.
You can lordship consider 2 months more, Lord. We have to sell this stock.
What you will do in 2 months? You
have to sell this, not this is all shoes which I bought from people.
Yes,
you have to sell them.
Miscellaneous matters completed.
Miscellaneous completed. Regular matter will not take. We are not taking up.
One small request.
One
small request in 101.
Yes.
Just a small request in 101, my lord. Lords have directed us to file one of the deposition which was not filed by us. But there has been some technical glitch we have not been able to file. Carrying up, my lord, may kindly give me fresh direction so that I file that in the counter physically.
Both of them are so happy when she said.
You too. Lords had a marathon, lords.
Yes.
My lords, I need fresh directions from my lords to file that additional document, my lords, because my lords.
Fresh direction? When there is a one direction,
no, my lords, the time expired, my lord. There was some technical glitch carrying a printout. So it says that the matter is.
Item number 101.
Yes.
So for the petitioner.
Yes, appellant.
101 million. The petitioner is allowed 4 weeks time or 2 weeks.
2 weeks, lords. We are ready with that.
To file additional documents.
And written submissions.
And written submissions. Post after 2 weeks.
But I got mention 102. It's a very, very short matter. It retains position a lot in the coming week.
For the respondent in this matter,
102 is a very short matter. Will it retain its position in the coming week?
I guess if it is not taken up, it will automatically be repeated.
I have a small request in 103. Instead of the next week, it could come in the week on 28 or 29 January. Great for me.
Thank you. अरे किसी को बुलाया
नहीं आया कहीं